on our website at longmontchamber.org. So be sure to check that out. All right, so for today, Tina, our speaker, is going to go through a number of different new employment laws that every business, every employer really should be aware of in this new year in 2021. And so what we'll do is she'll go through one, and then after that, there'll be a small break, and you can ask questions of her about what she's just spoken about. To ask a question, please put that into the chat section. And then when we get to that time, I will read the question aloud, or Kathy Stevens on our chamber staff will read the question. At that time, if you would like to clarify your question or you have a follow-up question, then you can go ahead and speak up at that time, but we're just trying to make it easy so people aren't speaking over each other if we follow that format. Today's event will go from now until about 3:30. So we would love, of course, if you were able to attend with us the entire time. If you are not able to, this event is being recorded. And so we will have it up on our website shortly after. But we encourage you, of course, to stay in attendance. That way you can get your question answered. All right, so Tina is joining us today, and she is an employment law attorney and the director of the Employer Council's Northern Regional Office in Loveland. She represents employers in a wide variety of employment law matters. She is a frequent speaker and facilitator of training on topics including legal issues, managing employees, harassment prevention, civil rights, employee medical issues, diversity, and other subjects. So with that, Tina, I will turn it over to you.
Thanks, Scott. And thanks everyone for being here this afternoon. I always look forward to any opportunity I have to talk to business people about and their employment law compliance concerns. You know, we are a membership organization. Employers are members of our organization to get employment law support and human resources support. And we're also a member of the Longmont Chamber, and we appreciate the programming that the Longmont Chamber provides. And we like to be a part of that programming to the extent that there is some new and important things that you need to know. So that's what I've prepared today, is an employment law update. We are going to spend most of our time on Colorado changes that are recent or upcoming in some cases. And these are things that all businesses, or most businesses, regardless of size, are going to need to know. So I will try to make sure that I indicate what businesses are covered as we go through. If I forget to do that, please don't hesitate to ask a question just to confirm. And I will, before you ask, maybe somebody's already asked, I will share my slides after this session so that they can be distributed to attendees from this. And of course, any follow-up general questions, I'm glad to answer for you. So
that's just her next screen or something.
Tina, sorry to interrupt, just one note. I think we're back on the slide with your notes and everything.
Okay,
so
let me.
2 to 3 different slides instead of just the one.
Oh, goodness. Okay, hang on one second. I think I should be able to fix that. Hold on. How does that look?
Yes.
All right.
That looks great. Thank you.
Thanks for letting me know. You guys could have just read my notes and then you would know what I was going to talk about. So this is the plan for our time together today. And I just want to talk a little bit about the change of administration. Of course, that's not fully formed. Things are very much in progress when it comes to changing from the Trump administration to the Biden administration, and from a Republican administration to a Democratic administration. But we'll just talk a little bit about some of the things that President Biden has indicated as his priorities for workers in the United States, as they will impact us down the line as employers. Also want to make sure you know about minimum wage changes that occurred in Colorado on January 1. And the comps order number 37 is is a order that affects private employers, regardless of size, in Colorado, and has certain requirements that are in place for both your non-exempt and your exempt workers, and we'll go over that. There was actually a pretty big change last year in the midst of all things COVID in March of 2020, where we switched from what you might be familiar with, which were the minimum wage orders, to comps order number 36. The biggest change there is that coverage was expanded from just certain private employers in 4 specific industries to all private employers. So that's why it's still in my deck of legal update, to make sure that you know that that's switched, because you may have not been a covered employer in the past, and you may not be familiar with that requirement. So I'll do those pieces, and then we'll take a break for questions at that point. The Equal Pay for Equal Work Act is a big piece of legislation that took effect, again, for all Colorado employers, public and private, January 1 of this year. And we're getting a lot of questions from our members, so I'll spend some time on that. We'll take questions after that. And then I'm going to dig into the federal and Colorado paid leave laws. And this is another area where we're getting a lot of questions. I'm sure you have questions. We'll talk about what's happened with the Families First Coronavirus Response Act, which is the federal leave. Then we'll spend some time on the Colorado Healthy Families and Workplace Act. We'll actually spend most of our time there. And I'm going to throw in a little bit on Proposition 118, but since that is further down the pipe, I'm not going to spend too much time on that. I just want to give you a little flavor of what is coming when we're talking about Proposition 118. And then we'll take another break for questions, and we'll finish up with some new whistleblower protections that I'm finding a lot of businesses were not aware of, having come into play last summer. And I want to make sure that you know about those. So to start, just as an overall comment, I guess I would say Democratic administrations tend to be more worker friendly, and Republican administrations tend to be more business friendly. And that's just a general remark, not on any particular president, but that's something to know. So we've seen President Biden's campaign plans, and they are starting to be put into action with different executive orders he signed, of course, changes in staffing. If there were pending rules that he felt should be different, or his staff felt should be different, some of those have been put on pause or even rolled back to the extent that they were not final. So at this website, it's on his workers page, he talks about promising aggressive wage and hour enforcement. So how might that show up? Well, he's looking at a minimum wage increase, and we have already had the Raise the Wage Act, which has been proposed before in the federal Congress, been reintroduced in the current Congress. And that is a bill that would raise federal minimum wage. We'll talk about state here in a moment, but would raise federal minimum wage to $15 an hour nationwide. And it would do that in 4 steps over 4-year time frame. So we are seeing that being debated by our current Congress. We're also seeing, we've seen an end to an amnesty program that the Wage and Hour Division at the federal level had in place, where an employer could, if it realized that it had violated the federal wage and hour law, it could turn itself in essentially and commit to making the correction and pay any back pay to workers, but not be assessed any kind of penalties, which are in the discretion of the Wage and Hour Division to impose. That paid program has ended, and that's really so that the Department of Labor can litigate those claims if they find problems. And the Biden administration has indicated that he would like more people to be eligible for overtime. So how we've seen that done in the past was raising the minimum salary level required for employees to be exempt under the federal law. And we had that occur a few years ago. And change, the other possibility for that would be to change the duties tests that are required for people to be exempt. I haven't seen any movement on either of those things yet, but we'll keep an eye out for those kinds of things. Also, on the campaign page is an encouragement of union organizing and collective bargaining. So more workers becoming unionized, and the collective bargaining is the process that they engage in with their employer to come up with their contracts that govern their employment. So of course, collective bargaining is more leverage, right, than one worker bargaining with its employers if it's all the employer's workers or a large group of workers bargaining with their employer. There's information in there about eliminating restrictive agreements. So what do I mean by that? I mean things like non-compete agreements, which are already hard to do, and not a lot of employers do those. Those are the ones where an employee signs off and says, I won't work at a competitor organization or otherwise compete with you for a period of time after my separation from employment. There are also no poaching agreements, or they're also called non-solicitation agreements, which are agreements that say where the employee agrees, after I leave, I'm not going to take your customers or your employees with me when I go. And then arbitration agreements. So those are the agreements that employers might ask employees to sign to agree to submit any disputes to a alternative dispute resolution process of arbitration rather than going to court. And the reason to do that, of course, is it's a quicker, less costly process. It's also binding on both parties, but it does deny people their day in court, which is what the campaign plan says we don't like about those. And then lastly, and we're already seeing this, is there'll be increased focus on workplace safety and health. So already OSHA has issued a revised safety guidance for COVID-19 for workplaces. And I think we will see them go further to creating an actual standard. I don't know that to be sure, but I think that they will, they may come up with that. Some states are putting out COVID-19 standards. So we'll see if the federal agency follows that tack. And I think we will see, although we haven't really to this point seen very much of this, is some more enforcement of those workplace safety and health standards with regard to COVID-19, and potentially some citations and investigations around that. So let's talk a little bit about minimum wage. So these are the current standards. So under the federal law, since 2009, our minimum wage has been $7.25 an hour. However, Colorado has had a higher minimum wage pretty much that whole time. So we have two constitutional amendments in Colorado that affect our minimum wage. One of them passed, I believe, in 2006, and that adjusts our minimum wage each year based on inflation. So the Colorado Department of Labor and Employment in the fall takes a look at the consumer price index for, I think it's the Denver Boulder area, and they make a determination on where to adjust the minimum wage from there. Subsequent to that, we did have in 2016 an amendment to our Constitution that increased our minimum wage sequentially over 4 years to $12 an hour. And that just ended in 2020, right? We went up to $12 an hour in 2020. So now we're back to the first amendment where we're making adjustments based on inflation. And the adjustment that was made from 2020 to 2021 was 32 cents an hour. So that makes Colorado's minimum wage $12.32 per hour. And you might recall in 2019, the Colorado legislature removed a prohibition that was in our laws that said localities cannot have a minimum wage. And Denver jumped on board pretty quickly with setting their own local minimum wage. So their minimum wage started out, I think, at $12.85 an hour, and now it is $14.77 an hour. Now there are sub-minimum wages for tipped employees and for youth workers and some other things that do exist under federal and state law, but these are the basic standards for all employers to follow. And the rule of thumb is whichever results in the greatest payment to the worker. So you don't get to pick. You might pick the blue circle and of $7.25 an hour, but that's not what you get to choose. Most employers are going to be in the middle circle in the green, and then those of you who operate in Denver would be in the gray circle. So the comps order I mentioned earlier is a shift from the minimum wage orders to comps orders that occurred first in March of 2020. And that was with comps order number 36. So comps order number 37 went into effect January 1. Why did we need a new one if we had one in March of 2020? Well, because minimum wage changed. That's the major change. There were a few other minor changes from comps order 36, but mostly it was the minimum wage change. And one thing I want to highlight that might have escaped your notice from March of 2020 is that there were new posting and distribution requirements with these orders. So not only do they cover more employers, so they cover all private employers, but you don't just have to put a poster on the wall. The comps order number 36 and continuing forward from there also requires that if you have a handbook, right, and you require employees to sign off on your handbook, which I would recommend you do, and many employers have handbooks, then you do need to include either the order itself, which is a pretty long document, or the comps order poster, which is a one-page document, probably what you're going to choose, in your handbook, and add a separate acknowledgement of receipt for just that comps order piece. So if you haven't revised your handbook since March of 2020, technically, I don't think you've triggered that requirement. But certainly the next time you do revise your handbook and distribute it to your employees, you will want to include the current version of the comps order. I would suggest the poster rather than the full order, and an acknowledgement of receipt for that. So what did the comps order do? Well, I told you it has requirements for non-exempt and for exempt employees. So just so we can resolve this mystery, the minimum wage orders used to cover employers in health and medical, employers in food and beverage, something called commercial support service, which is where an employer lent out service workers to other businesses. So temp services, custodial services, some things like that. And then finally, it was retail and service establishments. So those included banks and other financial institutions, but mainly retail businesses that offered their services or products to the consuming public. So that was a big group, but it still wasn't everybody. Now this order applies to manufacturing, it applies to construction, it applies to nonprofits, right? The rest of the private sector grouping. And what it requires is, in addition to the weekly overtime under federal law, there is a daily overtime component for non-exempt employees. So if they work over 12 hours in a day, they can also receive overtime pay at 1 1/2 times their regular rate of pay. That's not in addition to federal overtime, which is over 40 hours in a work week that you designate as the employer. But you do have to do both calculations and again, pay the worker whichever results in the greatest payment of wages. And your payroll system should be able to do that for you in the modern era. The order also requires meal periods. And the meal period is required for your non-exempt employees. That's your overtime eligible folks when they work at a shift that exceeds 5 consecutive hours. It does need to be 30 minutes in length and uninterrupted by work, but you do get an out if you cannot provide an off-duty meal to an employee, then you can allow them to consume an on-duty meal and just pay them for that 30 minutes of time. The one change that came about with the comps orders is that the meal period is not supposed to be in the first hour or the last hour of the employee's shift. So they're trying to move that more towards the middle of the employee shift. For rest periods, it's a 10-minute paid rest period, approximately every 4 hours that your non-exempt employees work. Now, the change with the comps orders is that we used to have an out for rest periods, kind of like the meal periods. If you couldn't get it in, then you just had the employee work and paid them for their regular amount of time. Now, if we miss a rest period, the order actually requires an employer to tack on another 10 minutes to that person's time worked for that day, even though they didn't get that break and even though they didn't work that time, and include that 10 minutes in an overtime calculation. So that upped the stakes considerably on the rest periods. Also, the order has more stricter rules for what is considered hours worked. So under federal law, little bits of time that it takes for somebody to say boot up their computer or get from the time clock to their desk didn't really count as work time. But now, if a pre-work task or an after-work task takes the employee more than a minute to perform, again, this is your non-exempt folks, then you do need to include that as time worked in their work day and make sure that they're paid for that time, and that time is included in the overtime calculation. There are other limits in the order on deductions, credits, charges, that you would want to take a look at if you are a covered employer and you're unfamiliar with this order. The change I want to highlight for exempt employees is an increase in the minimum salary that's required for an employee to be exempt from overtime. This is not the only requirement for an employee to be exempt from overtime. I mentioned that they have to perform exempt duties as well. They also have to be paid on a salary basis, which has its requirements. But this is a minimum salary required for someone to be exempt from overtime. And the federal requirement is $684 a week, or $35,000 and some change for the year. Now in Colorado, as of January 1, that has increased under the state law for private employers. Again, we're talking just about private at this point, to $778.85 a week, or $40,500 in a year. And there are 3 more annual increases planned to this minimum salary level. They will occur on January 1 of 2022, 2023, and 2024. And as of January 1, 2024, the minimum salary required for exempt employees is going to be $55,000 a year. So maybe you're fine under the $40,500, but you're going to want to look ahead to the subsequent jumps that are going to be occurring to see if you're still going to be fine, or if you're going to have to reclassify some folks or increase some pay for those exempt employees down the line. And then after 2024, there'll be an annual adjustment based on inflation. So kind of like how minimum wage was adjusted from $12 an hour to $12.32 an hour from 2020 to 2021. There'll be something similar as an adjustment to the weekly and therefore the annual salary for an exempt employee. So before I go on, Scott or Kathy, do we have any questions from the participants?
I don't see any questions in the chat section right now. So if you do have any questions, be sure just to put them in there and we will get those answered for you. So, but not at the moment.
All right, great. I must be doing a good job.
So we have one here.
Okay.
Myra, do we need to include the comps order number 37 one-page sheet in our handbook, even if nobody works hourly?
Yes. That's a good question. And yes, it does require that. If you have a handbook, because there is components for exempt employees as well in that order. So good question. Thank you.
Okay. And Rebecca asks, should we add this to our employee handbook if everyone is compensated well under 45K? So I think she probably was similar questions, probably writing that at the same time. Okay.
Yep. Same answer to that one, Rebecca.
All right. And if you have the poster up in your office, does that suffice, or do you still need to include it in the handbook? So
you need to do both now. So that's why I wanted to highlight that, because before it was always just fine. And for most other laws, it's always been fine just to put that poster up. And now they have this additional requirement.
okay, great. And then the next question is the same, really. I believe you said in the handbook or the poster. So you've answered that with both.
It's both, yes. All right, so let's talk about the equal pay. Sorry, Scott, was there another question?
Those are the questions. Nope, we're good. Thank you.
All right, so now let's talk about the Equal Pay for Equal Work Act. And I know you're probably thinking, don't we have a federal law on this? And yes, we have had a federal Equal Pay Act since 1963. However, there was a lot of activity, particularly following Me Too, but even prior to the Me Too movement, on pay equity based on sex in the United States. And several states, 17 of them, in fact, have passed different pay equity laws. Colorado's actually passed in 2019. If you remember back that far, pre-COVID, that's the environment under which this passed. It was given a 2-year run-up, right? So time for employers to prepare, because all employers, public or private, are covered by this law. So, but that time frame, of course, got a lot shorter with COVID interrupting our business processes. So the Equal Pay for Equal Work Act became effective January 1 of this year. It is not retroactive. That means that people cannot file suits as of February 10th, today, and try to recoup money that they say they were not paid prior to January 1 of 21. So that's what I mean by not being retroactive. It really is from January 1 forward that people can file claims and recover any kind of damages. As I mentioned, it covers public employers, so that's government, that's state and local government, it's political subdivisions, it's special districts. That's what we're talking about when we're talking about public employers, and private employers, which is everybody else who employ a single person in Colorado. And the exception is the federal government. There's also an exception for people who are receiving railroad unemployment, which is a small exception. I didn't put it on the slide. And it covers all employees that work for your organization. What it prohibits is pay discrimination based on sex, or sex plus another protected status. So there, you've seen probably the data on the differences between pay of men and women in the workplace and the inequities that happen there. But also when you add other protected statuses in addition to being female, those inequities grow. So sex plus race, sex plus age, sex plus national origin are just some examples of that. So it does have to be sex discrimination at its core, but it could also have another layer, or what they're calling kind of an intersectionality of two different types of discrimination. Or it doesn't have to be just two, it could be even more than that, if that's what's happening. It also prohibits seeking wage history of applicants. So if you have those kinds of questions on an application form, which many employers did, and maybe still do, you need to remove those. If you ask it in an interview process, or if you've got something else pre-employment where you inquire about wage history, you need to change those processes now. You can ask wage requirements or salary requirements, or another way that it's put is salary expectations. That's an okay thing to do. And that's how I would shift if you feel like you need that information to make a job offer. Employers cannot rely on wage history to set pay anymore. So I'm not saying that you did, but some employers, they found out what the previous employer paid and they offered a little bit more to the person to come on board with them, and that might have worked for them. It will not work as a compensation system now in Colorado. The other pieces are prohibiting discrimination against applicants or retaliation for failing to disclose their wage history. You cannot take adverse action against employees for discussing wages, and you cannot ask an applicant or an employee to sign a waiver that denies them their right to discuss employees' wage rates. So there's some finesse to this, right? If you've got a payroll person, you can tell them that they can't disclose everyone's pay in your company, but they can discuss their pay with their coworkers and even with third parties. And that's not just true under this new law, but that's been true under other laws in Colorado and under federal law that have been in place for some time. So you don't want to have those policies, which I sometimes still see, that say you can't discuss your wages with anyone else. So how do we figure out if pay discrimination has occurred? What this law says is that it doesn't matter what the job titles are. You need to compare jobs based on whether they perform substantially similar work. And we don't have any cases under the Colorado law yet because it just took effect last month. But typically under other state laws that are similar to Colorado's was modeled after California's and Massachusetts equal pay laws. And under the federal Equal Pay Act, what they look at is skill, effort, and responsibility. So skill is measured by factors like experience, ability, the education or training that is required for the job. And then effort would be things like the physical and the mental exertion that you put into the job. And then responsibility is the degree of accountability that someone has to perform that job. So factors that can justify pay disparities amongst employees of different sexes who are performing substantially similar work for your company are these, and only these, 6 factors. And these 6 factors need to fully explain any disparities in pay you have amongst those, again, people performing substantially similar work that are of different sexes. So what you don't see up here is market. And that's what has worried a lot of employers as this law has gone into effect, because market certainly does impact what we need to offer people to come on board. So for example, if you hired somebody in 2010, right, in the midst of our Great Recession, you probably hired them for less than what you hired someone for in 2019, when we had a very, very low unemployment, scarcity of workers. We were all vying for the same skilled folks, and they were just hard to get, right? So that's what I'm talking about when I'm talking about market. And that has messed with compensation structures for a long time, well before the Equal Pay for Equal Work Act, but it's going to be more of a problem now. So you really do need to have a foundation for how you value the work that is performed by employees in your company. And I would recommend that you have that documented. This is how we determine what we pay for positions. These are the things that factor in, and we got to stick to that. So this is going to take away some of that latitude and discretion perhaps you've had in the hiring process, or certain of your hiring managers have had, to get that sought for candidate that they really want. And it's just going to take a few more dollars to do that. But doing that might not be consistent with your plan and potentially expose you to a pay equity claim. So the factors that can justify pay disparity, hopefully there's no surprises on this slide. Seniority, we know, is length of service, right? Merit is how the employee does in the job. But you do need some kind of a system, right, to evaluate merit. And maybe you do have a performance evaluation system, you do some kind of rating or ranking, and you tie that to the pay increase the employee receives. That's what we want to see for merit. For quantity or quality of production, how do you measure that? Quantity might be a little easier because it's numbers, right? Quality, how do we measure quality of production, and how do we evaluate that in an objective way, and then tie that to the pay or the pay increase that an employee will receive. Geographic location, it costs more to live and work in certain areas. It costs more to hire people because of that higher cost of living in certain areas. If your pay does fluctuate based on geography, I would recommend that you have that data that supports, what the change in the cost of living is, and what economics factor into that. So are we talking about Denver to Colorado Springs, right? Housing's cheaper, maybe other things are cheaper, maybe pay is less. So you're going to want to keep that information that supports that decision. Education, training, experience related to the work, of course, it's got to be related to the work. If you hire me as an attorney to do a job that doesn't require a law degree, then my law degree can't explain the difference in the pay that I have from a worker doing substantially similar work. But to where the education, training, and experience is required for the work, absolutely that makes a difference. So keep resumes, right? Inquire about this stuff during interviews and keep your notes, and verify employees' education and applicants' education. Whoops, getting a little overzealous here with my clicker. And then finally, travel. So if regular travel is necessary for the work, you might provide a bump. So I talked to a company the other day that has people traveling internationally, and they pay a premium because of that inconvenience, right? Or that additional responsibility versus folks that travel locally, right? So you're going to want to be able to quantify that as well. And again, you apply each of these factors reasonably to explain the entire difference in pay amongst those people who are different sexes performing substantially similar work. The law also requires posting promotional opportunities, and I have more on this. This is where we're getting a lot of technical questions. Do I have to post this job? So we will go over that. And I would just say, as a rule of thumb, when in doubt, post, because it is very broad as far as this goes. You also have to keep records. So you do need to have job descriptions for all your positions. If you do not, that's your first step to compliance. And you keep the job descriptions for your employees for the positions they have held in their personnel files, right? Or you could use another spot, but usually it's the personnel file. And you keep their wage rate history throughout the time they work for you and 2 years after they leave. The Colorado Department of Labor and Employment has been given the authority to fine employers for posting and record keeping violations. Now, typically when a law is new, they're more helpful and they don't always fine employers right away. Or if they do fine you, you might be at the low end of the spectrum. And it goes up to $10,000 per violation. I don't think any of you want to experience that. Employees have a lot of options when it comes to equal pay for equal work as far as where they can go. They can go to the Colorado Department of Labor and Employment and make a complaint. They can also go to the Colorado Civil Rights Division and make a complaint. And they don't have to do either of those processes. They can go directly to court. And the plaintiff's attorneys, the plaintiff's employment bar, was very involved in getting this law passed. So I think they've probably already picked out who they think are some of their potential plaintiffs. And of course, they're waiting to get a little further past January 1 of 2021 when this takes effect to file those lawsuits. But they're probably going to go directly to court with those kinds of things. And that's, of course, more expensive. That's more stress and strain on your organization and a drain on productivity to be stuck in litigation. Employees have 2 years to file their claims, but that 2-year deadline keeps restarting each time they get a paycheck that is based on a discriminatory decision. So employees are going to have plenty of time, most likely, to get these claims filed. They can recover up to 3 years of back pay. So what do I mean by that? By back pay, I mean the difference between what they were paid and what they would have or should have been paid, but for the pay discrimination. So it's going to be that differential for up to 3 years. So really, somebody can't recover a full 3 years of back pay until we get to January 1 of 2024. So actually, these lawsuits that we're going to see might be even more delayed. They can also recover what is called liquidated damages. So liquidated damages is an amount equal to the back pay awarded. And what this law says is that the liquidated damages are there to compensate the employee for the delay in receiving the amounts they should have received as a result of the employer's pay discrimination violation. Now we're going to talk on the next slide about a way employers can avoid liquidated damages, which you will want to do for your business. You can also recover what are called equitable remedies. This is not money: reinstatement, promotion, pay increase, and employees who prevail can get their costs paid and their attorney's fees. And I could just say that litigation is expensive, and some of those costs and attorney's fees can be as much or more than the back pay or even the liquidated damages amounts in wage and hour litigation. So this is the employer's defense against liquidated damages. We need to show our good faith. How do we show that? We show that we have been reviewing our compensation systems to root out pay equity issues. So if we have done a pay equity audit within 2 years of the beginning of a claim against us, then that will be evidence of good faith. And again, that cuts off the liquidated damages, but it does nothing with the back pay. We're going to still owe up to 3 years of back pay to employees, but it doesn't double what we owe them, which is very nice. And again, something you will want to do. Also want to make sure you know that if you don't keep the required records under this law, that the Department of Labor and Employment has said can be evidence of bad faith. So I know that's nobody's favorite thing to do is record keeping, but it's an important thing to do. Posting requirements. You need to post all promotional opportunities to current employees. And I'm going to say current Colorado employees in case you employ people multi-state. We need to do this on the same day as we make any external posting. You do not have to post jobs externally, but this law is going to make you post them at least internally to your Colorado folks. But if we do post externally, the posting to current employees comes out on the same day, and the posting needs to be done prior to making a decision about who gets that promotion. So it can't just be form over function. We put the posting out, but there was somebody in line to get that position. You can use any method where all your employees can access that from their workplace. Now, again, many of us are working from home, maybe not working from work. You're probably doing these online, and that's fine. You can also do this in hard copy. And employees need to be told where to find postings. So I would recommend, that you do a little bit more, as this law is new, to direct people to your intranet page or your extranet page, right, on the job postings, so that they know where to find things. Maybe you didn't put emphasis on that in the past. It would be good to put some emphasis on that now. What's a promotion? I mean, we thought we knew, but the Department of Labor and Employment has given us a broader definition than maybe we thought. So it's a vacancy in an existing or new position that could be considered a promotion. So you see that flexible language could be in there for one or more employees. So typically we think of a promotion as a competitive process, not something we do with just one employee, but it is something that we do with just one employee under this new law. So, and it's a change in their compensation, benefits, status, duties, further advancement. So this is big and broad, and it is going to include those inline progressions that you have for one employee in your company. So one of the examples from the guidance put out by the Colorado Department of Labor is an apprentice 1 going to an apprentice 2. Now that's not something you would probably post pre-January 1 of 2021. And that is something the Department of Labor does say needs to be posted now under the new law. What's a vacancy? Well, we thought we knew that too, and we do, right? If it's an existing position, it's where we intend to fill that. It's either open or there's a departing employee in that job. It's also a new position. So if we add, that is a vacancy. Sometimes we don't think of that as a vacancy. And it's when we change an existing employee's position. So if we change their job title and or is the language, believe it or not, from the rules, if we change their authority, duties, and opportunities, that is a vacancy as well. And that one, I guarantee you have not been thinking about as a vacancy or something that you might need to post. What's not a vacancy? Pay changes. Yay, they're not vacancies. Neither is adding an externally obtained degree or a certification. Postings have to be in writing, so they can be electronic or they can be in paper. They have to include job title and compensation and benefits information in most cases. There's one exception to that, and we'll talk about what that looks like next and how employees can apply. The compensation and benefits information. So the first one is a number. So you're putting in the hourly rate or range or the salary rate or range for the job. So this is the hiring range, not the full range. If you've got job ranges put out, you give employees room to grow. You know, you don't have to put that entire range, but you certainly want to put the starting point of that range and perhaps up to the midpoint of that range. So you have some flexibility where you might offer a candidate what you might offer for that job. The next two bullets are words. So it's just a general description of any bonuses, commissions, or other compensation that goes with the job. So you don't have to get detailed here. You can say bonuses, commissions, right? Profit sharing, or whatever it is. And then the third bullet is also words, a general description of the benefits. And these are the ones that come out of the rules that you should include if you have those. Healthcare, retirement, paid days off, and other tax reportable benefits. So really, again, you don't have to get into values, you don't have to get into dollars, you don't have to get into cost sharing or anything like that. You just say the job comes with health insurance, and that is sufficient. Now, there are some allowances in the rules for linking to this information. If you want to link to your other compensation and benefits information from the posting, you could do that, such as if you had a benefits page on your jobs pages on your website or on your intranet internal to your company. You could do it that way. You just have to make sure that that information that you're linking to is current and that those links work. So there's a few exceptions to the posting requirement. One is where we haven't told the person who's in the job that they're not going to have that job anymore. We don't have to post that until we let the departing employee know what's going on. But we do need to post it when we do make that notification. You also do not have to post an automatic promotion within 1 year of hire if you reduce that automatic promotion to writing. So you could do that in a policy. The rules also say you could put that in an offer letter or in a contract. I would not recommend, if you're an at-will employer, doing this in an offer letter or a contract. Maybe a policy, because that's promissory and that takes you out of that at-will space, and I don't want you to do that. You also do not have to post temporary acting or interim hires that are up to 6 months. once you figure out that's going to be a regular job in your company, you do need to post it. There's also geographic limits. So I mentioned that promotion postings don't apply or only apply to your Colorado employees earlier. Well, here's where that comes from. If employees are entirely outside of Colorado who work for your company, they don't work in Colorado, then you don't need to post positions, promotion positions to them, unless you want to. You might want to. And then compensation, the compensation and benefit requirements don't have to be included in postings for jobs that are to be performed entirely outside of Colorado or postings that are entirely outside of Colorado. It's going to be pretty hard to have your posting be entirely outside of Colorado unless you're doing like newspaper. Most people are doing online postings and that goes everywhere. So it's probably that jobs to be performed entirely outside of Colorado where you would exclude the compensation and benefits information. All right, Scott, how are we doing on questions?
Okay, we actually have a couple here. So, oops, we've got a few more, so let me scroll up here. Is there a template or an example of what sufficient record keeping looks like to document pay rates for different jobs, audits, etc.?
You know, there isn't. That's a good question. So, you know, if you've got an HRIS system, they probably have something for tracking pay increases in that system. If you don't have an HRIS system, you could, if you have a payroll change notice, that's what I'm used to seeing employers doing. If they have a physical form, it's just a payroll change notice where you're saying, we are increasing this person's pay, or we're promoting this person and increasing their pay. Usually I find that those are in the personnel file. So it doesn't dictate how you need to do that.
Okay. And second question, if we have a company with only one project manager and we promote him to senior project manager, and there are no other project managers, do we still need to post the job with the salary ranges?
Yes, because you're changing the job title and you're changing responsibilities, I'm assuming, from junior to senior. So I'm assuming there's something that changes about the job with that in addition to the job title. So yes, those are the kinds of questions we're getting, and people are, you know, their chins are dropping or jaws are dropping when I give that answer. But with what we have now, you would need to post that.
Okay, and I think this is a similar type question, but Ryan asked, if I hire my employee to do bookkeeping data entry and then ask him to reconcile the account, does that constitute a change in duties and need to be posted? How granular does this get when assigning new duties to current employees?
It's a good question, Ryan. And honestly, we don't know how granular this gets. Now, it does say a job title and or material change in duties, responsibilities, status, right? So we're going to be fighting about how material is a change. So, but if you change title and something else, I would say yes, like in the junior to senior project manager, I think that is addressed. You're just adding an additional duty may skirt around the edges of this, and we'll have to see how granular they get.
Okay, those are our questions for that. Oops, here we have one more. Does it matter where we post as long as employees know where to go see the post?
No, you can use any reasonable method. Again, it could just be internal, right? Or you could refer them to your external source where you put postings. It does not matter where you post. It's as long as everybody can get access to it online or in hard copy, and they know where to find it.
Okay.
All
great.
right.
Those
Ready to
are
talk about paid leave?
Yep, and I'd like to just do one reminder. You can drop questions in the chat section at any time. So if you've got a question and you think you'll forget it by the time we're done with that segment, go ahead and put it in the chat section. We'll get that answered for you. So actually, we do have one more from Myra that just came in. All these
Okay.
postings do not need to be applied to anything that happened before January 2021. I believe that is correct, but Tina, will you confirm that?
Yes.
Okay.
Yes, that is correct. And they actually extended it a little bit beyond January 1. And they said if the posting was down by, it was up before January 1 and down by February 1, you didn't have to worry about that one either. But now we're in February, so now we're subject to the rules.
Okay. And
All
then
right.
Michelle, yes, we will be sharing this recorded session, and Tina will be sending her slide deck as well. So yes, you'll be able to access it on our website and also the slide deck.
Absolutely. And that's why I put the date on the cover slide,
Yeah.
because things are changing. So don't go back to this a year from now and say, Tina said something might have changed since then. But for right now, this is what we've got. So we're going to talk about paid leaves of absence next, starting with the Families First Coronavirus Response Act. This is the federal law that went into place in April of 2020, April 1st, and was set to expire December 31st of 2020. And this put in place two different types of leave for employees affected by COVID-19. So there was an emergency paid sick leave component, and that was up to 2 weeks or 80 hours of leave for employees who got COVID, who had symptoms of COVID and were seeking a diagnosis, people who were under isolation or quarantine orders, people who were taking care of family members that were under isolation or quarantine orders or had COVID. And then it also covered where an employee had to take care of their minor children who were not in school or not in daycare because of COVID-19. So that was a 2-week leave. Then there was a separate leave under this federal law, which was a Family Medical Leave Act expansion leave that allowed up to 12 weeks of leave, but only for parents with kiddos who didn't have care or didn't have school due to COVID. So as I said, this law had a start and an end date, a start date of April 1st and an end date of December 31st of 2021, or 2020, excuse me. I know my years. And it did end as far as the entitlement to leave. That ended 12/31/20. But Congress did continue the tax credits for eligible employers who chose to voluntarily extend any remaining leave employees had from 2020 into the beginning of 2021. So just through March 31st of this year. So who's eligible for the tax credits? Well, it was employers with fewer than 500 employees, right? And it was private sector employers, not public sector employers. So it's optional at this point for employers to provide any additional Families First Coronavirus Response Act leave. But if you can get it paid for by the federal government dollar for dollar, right, through the tax credits, some employers are considering doing that. If you are doing that, you need to follow all of the FFCRA rules, right? So you can't just claim the tax credits and not take the whole thing into consideration. Now, we are hearing talk of the possibility with a new COVID relief bill or stimulus bill being debated of an extension of the Families First Coronavirus Response Act leave. That has not happened yet. So again, right now, the entitlement to leave has ended and only the tax credits continue for employers who voluntarily choose to extend any remaining leave to their employees. So what do I mean by remaining leave? If my employee took 2 weeks or 1 week of emergency paid sick leave in 2020 and had 1 week remaining, and then had a circumstance that qualifies for emergency paid sick leave in the beginning of this year, then you could pay the employee for that time and essentially just deduct it from what you pay the government in your payroll taxes. Now, one thing that Colorado employers need to be aware of is that we also have coming into play the Healthy Families and Workplaces Act. So these laws were not written in consideration of each other because the federal law was supposed to go away at the end of 2020 and the Colorado law was supposed to start at the beginning of 2021. So what I mean by that is there isn't an accounting for what you do when both of these could be happening at the same time for one employee. They cover a lot of the same reasons that an employee could be out. And what I want to tell you is that I don't have any information in either of these laws that says if you extend Families First Coronavirus Response Act into 2021, that you get to reduce what you have to provide under Colorado's Healthy Families and Workplaces Act. So another way to say that is employees could end up getting both if you decide to extend Families First Coronavirus Response Act leave into 2021. So let's talk about that. The Healthy Families and Workplaces Act also has two types of leave. There is a paid sick leave requirement that is in place right now only for employers who have 16 and more employees. So your smaller employers, you will be covered by the paid sick leave requirement, but not until January 1st of 2022. The other type of leave is the public health emergency leave. And all employers, regardless of size, are covered by that. And our governor did trigger that requirement under this law beginning January 1 of 2021. So if you're a smaller employer, not yet subject to the paid sick leave requirement, which we'll talk about first, but every employer is subject to the public health emergency leave, which we'll talk about after the paid sick leave. So some elements of both, excuse me. As I mentioned, if you extend FFCRA leave, then again, you're still obligated to meet your Healthy Families and Workplace Act requirements. And these slides, I guess I already mentioned this. This is when the paid sick leave requirement goes into place for the larger employers and then all employers under the public health emergency. If you have existing leave benefits that meet or exceed whichever components you're subject to right now, either the paid sick leave and the public health emergency leave, if you have 16 or more employees, or just the public health emergency leave, if you have 15 or fewer employees, then you do not need to provide additional leave. You do not need a separate policy. And if you have a policy that's more generous, of course, that's fine. But you do need to make sure that your existing leave meets all of the Healthy Families and Workplace Act requirements. And from reviewing those policies, usually there are things that need to be tweaked. For both types of leave, when can your employer get documentation? So this may be one of those things that needs to be tweaked if you're using an existing leave. You can require documentation for paid sick leave if the employee is out for 4 or more consecutive work days. So you might have a sick leave policy that says we can ask for a note at any time, or we can ask for it after a shorter number of days. Now it needs to be after 4 or more consecutive work days. So that could be Thursday, Friday, Monday, Tuesday, with the break over the weekend. It could be Monday through Thursday, whatever it is. And documentation may not be required for use of public health emergency leave. So that was another jaw dropper for many of our members, that they could not, try to curb potential abuse of this leave by requiring documentation. But that is what the statute says. So let's talk about the paid sick leave first. So the paid sick leave is just general paid sick leave. It doesn't have to, it doesn't deal explicitly with COVID-19. So this is just putting in place a paid sick leave requirement that will be in place now until this law is no longer in effect. Act, and there is no end date on this law. So paid sick leave, the reasons employees can use the leave, this all looks pretty good, right? Employee or their family member is sick, right? Is injured, has a health condition, right? Needs medical diagnosis, care, or treatment, right? Or needs preventative care. So that's all probably what you already had sick leave for your employees. But it also includes when an employee or family member is a victim of domestic violence, sexual assault, or harassment, and needs to take leave for any of these bulleted items as a result of those things. So that may be one thing, again, if you have existing leave, you need to tweak because you didn't cover that under your sick leave. Maybe you didn't even think about that under your sick leave. Paid sick leave accrual begins the earlier of January 1, 21. So for your current employees, right, on January 1, they started accruing at that point, or when you hire someone from here forward. So it starts right away. So sometimes employers will have a benefits elimination period where they'll say you don't accrue any sick leave for the first 30, 60, 90 days. That would not work under if you're using that sick leave to meet Healthy Families requirements. So the rate that employees must accrue leave is 1 hour of paid sick leave for every 30 hours worked. And all employees get to accrue sick leave. So temporary, seasonal, part-time, full-time, or in whatever other eruditions of employees you have. Now, obviously, somebody who works temporarily or part-time is going to accrue it not quite as quickly as that full-time person, but that is the same ratio for all employees. Now, if you prefer, you can grant the leave as a lump sum instead of doing the accrual, and maybe your systems already do that. So what you would do is you would calculate based on what the employee is expected to work, right? What the amount would be for that year, and then you can drop it into a sick leave bank for them. Both the accrual and any grant is capped at 48 hours per year, right? So that's only 6 days if they're full-time. So it's not an enormous amount of time that you're required to provide. It still might be more than you provide, particularly to part-time or temporary folks. Employees need to be able to use leave upon request. They can use it as soon as they earn it. They can request leave in multiple ways. And if they don't meet your notice procedures, you cannot deny their leave for non-compliance. So what's left out in there is, could you discipline the employee for not following your call-in procedure? It's not addressed. So I think the answer is yes, but you still would provide them with that leave. Use of paid sick leave. Employees, I said you can use it as it's accrued. So their first week, if they work 30 hours, they've got an hour that they can use. Leave up to 48 hours per year can be carried over into the subsequent year. But again, accrual and use is capped at 48 hours in a year. So that is really the magic number when it comes to the paid sick leave part of this. You are not required to pay out under the Healthy Families and Workplaces Act any accrued unused sick leave upon separation. If you rehire people within 6 months of separation, then you do need to reinstate what they had when they left of paid sick leave, unless you did pay that out at separation. So that's a paid sick leave component. What is the public health emergency leave? So this is the mini FFCRA. This is what's very like the Families First Coronavirus Response Act. And this is what I said our governor triggered for all employers beginning January 1 of 2021 because of the current and continuing public health emergency of COVID-19. So this is a supplement, a one-time per public health emergency supplement, no matter how long that health emergency goes on, right? We need to supplement the employee's leave with another bucket of leave and this is granted lump sum, this is not accrued, that they can use particularly for COVID-related situations, right? And this leave is going to be available to them throughout that public health emergency and for 4 weeks afterwards. And if it is not used to exhaustion by that time, then whatever remains goes away. So this is another bucket of time that you need to separate out from even your paid sick leave that we just talked about. So full-time employees get a supplement up to 80 hours. So if they have 40 hours already, you're only supplementing another 40. Less than full-time employees get a prorated amount based on this formula, whatever is the greater of those two numbers. So public health emergency leave purposes are, again, specifically tied to COVID-19, the current public health emergency. And this is where it very much looks like Families First Coronavirus Response Act leave. So it's for isolating, right, due to COVID-19, seeking medical diagnosis or having symptoms of COVID-19, getting preventative care. So vaccinations and testing could also fall into here. If a public health authority or the employer even has determined that having that person at work could jeopardize others' health. So those are the close contact exposure situations where we are requiring employees to quarantine. That's also a purpose that they can use this public health emergency leave for. And if an employee is a parent, has a minor child that does not have care or school due to COVID. And what they throw in here, in addition to children, is also family member. So this could be an elder care situation, or maybe you have responsibilities for your parents or your spouse's parents, and they don't have care that they would normally have due to COVID. An employee could take this leave for that purpose as well. All right, we're moving on. We'll do Prop 118 and then we'll take some questions. So Proposition 118, I put this in because we're getting questions about it, but I really just want to say, hold on to your horses when it comes to this, because we don't have all the information we are going to have about Proposition 118. So first of all, what is it? This is the family bill. So family with an I was a bill that was proposed I think it's first proposed maybe in 2015 or 2016 in Colorado. And the bill was to create a state-funded or state-run, employer and employee funded paid family and medical leave for employees. So some states, a handful of states have these kinds of programs, and Colorado was set to join them. And each year the bill got closer and closer to passing, and 2020 was gonna be Families' Year, but it all sort of fell apart. Even pre-COVID, they lost some of their sponsors. The people that put the bill forward didn't like how it was being narrowed and wanted it to be broader. So they took it out of the legislature's hands and made it a ballot initiative. And we voted on it in November and it passed. So that's what Proposition 118 is. What does it do? It will give workers who are eligible 12 weeks of paid time off in most cases. There can be a 4-week extension in cases of pregnancy disability. So it could be up to 16 weeks in some cases. So the reasons for leave are similar to the Federal Family Medical Leave Act. So if you are a public sector employer or if you are a private employer with over 50 employees, you are currently subject to the Federal Family Medical Leave Act. If you're a smaller private employer, you may not know what those reasons are, but they are for the serious health condition of family members or the employee. And the Colorado law is broader in its definition of family member than just spouse, parent, and child, which is what the federal law covers. So there'll be more people that folks can take leave for. It's also for birth of a child, care of a newborn child, to bond with a baby after birth, those sorts of things. And it will be pay at a percentage of the employee's wage, no more than 90%, and capped at $1,100 per week. So they will be doing a calculation somewhat similar to what unemployment does when it determines what someone's weekly benefit amount is for purposes of that system. Only this will be a lot higher. Unemployment typically pays, 55% up to whatever maximum is currently in place. And I think the maximum for unemployment benefits under the state is somewhere around $600 a week. So this is higher, up to 90% and up to $1,100 a week. It's going to be funded by a payroll tax. So we voted for a tax. So half of that tax will be paid by the employer and half of that tax will be paid by the employee. So we're all going to have money coming out of our paychecks to go into this fund for people to draw from when they need paid family medical leave. The first deductions of taxes will not be made until January 1 of 2023. And the first benefits will not be paid out to workers until after January 1, 2024. So that's why I say, just hang on, this is not here yet. Employers that are smaller are exempt. Employees become eligible to receive benefits pretty early on. They only have to earn $2,500 from their employment to be eligible. And there are some pretty stiff job protections if the employee is employed 6 months or more that give them reinstatement rights at the end of their family and medical leave, assuming they're able to return within that allotted time frame. So it's something other than at will for a period of time, and then at will can resume. And employers will have the option of purchasing private insurance. So if an employer chooses to do that, then they bear the full cost. There isn't the payroll tax deduction where the employer pays half and the employee pays half. All right, so where are we with questions? I see Kathy there. Kathy, do we have questions about the paid leaves?
Yes, we do. I'm going to go back up to the top to the first item here. If the employer chooses to extend the FFCRA leave hours, is there any election or just claim the credits?
You need to keep certain documentation, and documentation is kind of a loose word. You need information about why the employee was out. If they're out for certain reasons, then you need additional information. So if they're out because they've been recommended by a healthcare provider to self-isolate due to COVID or a medical condition, you need the name of the healthcare provider and the contact information. If they're out due to their kiddos not having school or not having care because that was shut down due to COVID, then you need the name of the school and you need to provide information about the dependents and their ages and those things. So there is an entire FAQ on the Internal Revenue Service website on how to claim Families First coronavirus tax credits. And really you get to deduct from what you pay into the government quarterly for your federal payroll taxes. You can deduct that off the top. If you're paying out so much in FFCRA leave that is not enough money, then you will file, of course, there's a form, right, to get reimbursed for the cost. But I would check out that IRS website.
Okay. Next question, if we have a new employee in January 2021, they would not qualify for the hours because the hours were actually earned in 2021, correct? This goes back to
They would not qualify for FFCRA. Okay, I think that's what they're asking. Okay, thanks, Kathy. So you're correct. If they didn't work for you in 2020, when the entitlement to FFCRA leave was given, there is no new entitlement yet. We'll see what Congress does in 2021. So you're right, there is no FFCRA leave, but they would get Healthy Families leave.
Hang on here, I've got 4 more questions here. I have an employee that needs to take care of his child here and there, but still works 40 hours, so he gets paid full time. The public health emergency leave is basically giving him 80 hours for this, and these hours paid are tax credited. Those are both questions. Does that make sense?
Right, it does. And you can only take leave for hours you're scheduled to work. So if the employee is working their regular schedule and is able to work around that regular schedule, they wouldn't be taking any leave. It would be if they're not able to work their scheduled time that they would be able to use the Healthy Families and Workplaces Act leave.
Okay, next question. A statement about the public health order of 80 hours was given. Something about already having 40 hours. Can you repeat and explain? She understands the 48 hours for sick.
Okay, so that's the public health emergency leave. So what I said is that you have to supplement up to a certain level. You have to provide an additional supplement of leave. So if you have existing leave that, again, meets the Healthy Families requirements, you can take credit for that and supplement above that amount. So my example was if the employee already has 40 hours of paid sick leave accrued that meets the Healthy Families requirements, you only have to add an additional supplement of 40 hours to meet the 80-hour requirement if this is a full-time employee. If your employee has 0 leave that meets the Healthy Families and Workplace Act requirements on January 1, you're going to be supplementing the full 80 for a full-time employee. But if they already have some leave, you can count that in or offset the amount you supplement by that amount.
Last question. We have a policy which we call paid personal time, and it is a bit more flexible than the HFWA requirements. It allows 40 hours per year for all types of personal needs, including sick, and it is separate from our PTO policy. If we already have this policy, do we need to change the name of it to HFWA paid sick leave, or are we already in compliance?
The law says that an existing policy by any name can meet the Healthy Families and Workplaces Act requirements. So you do not have to change the name of the policy. You just have to make sure that the policy does meet the requirements. So you said 40 hours. The Healthy Families and Workplace Act is 48 hours as a max. So that may need to be an adjustment. But you don't need to change the name of the policy or add a new policy. You may just need to tweak that existing policy.
And just on my own, she says here it is separate from their PTO policy. Does that?
Well, I think it's just how you've structured your leave. So, what leave do you want to use to meet your Healthy Families and Workplaces Act requirements? You could use the PTO. Maybe that's a bigger bank of time. Again, if you wish to do that. Now, Colorado Department of Labor and Employment has said if you're going to use a general PTO policy to meet the Healthy Families and Workplace Act requirements, that you should include some specific language in that policy, letting employees know, essentially, that this is what we're doing to comply with Healthy Families, because they might not figure that out otherwise. With sick leave, it's a little more obvious. So if you're using a PTO policy, I would recommend adding that language. And the other important thing to add is a statement that says, look, you've got a bucket of time that you can use for non-Healthy Families and Workplaces Act purposes and Healthy Families and Workplaces Act purposes. If you use it all for non-Healthy Families and Workplace Act purposes, you're not going to get more. The only situation where they might get more is, again, if there's a new public health emergency, right, where we then have to supplement their leave. So you could use either or. I guess potentially both, but you're going to want to make some decisions about that and make sure that that is reviewed and it meets the requirements.
One more question popped up. There is no wait time to be eligible for public health emergency leave, correct?
Correct. No wait time.
And-
No, yeah,
Okay.
no benefits elimination time, right? So
Okay.
that, and that's again, specific to COVID, will go away once the suspension or termination of the current public health emergency happens.
And they added on, for example, an employee hired on January 15, 21, worked 2 days, then was out for 3 days with COVID symptoms. Are we required to offer those 3 days paid under the public health emergency leave?
They, we don't want to get too granular here in this general presentation, but I think so. Again, they when they came on board, they would receive that supplement. And if they had a leave that qualified, yes.
Okay. Next question. Can you please clarify that if we have less than 16 employees, we have to be in compliance with Healthy Families Act?
You have to be in compliance with the public health emergency leave portion of that act. You are not yet covered by the paid sick leave portion of the act. And that you will be covered by the paid sick leave portion January 1 of 2022.
Another question. If we elect to continue FFCRA and an employee has remaining hours, do we have to pay them the FFCRA and public health emergency leave? If so, then they get double pay?
They wouldn't get double pay. They'd get FFCRA first, but as I said, you might end up doing the full boat of Healthy Families leave as well. But no, you do not have to pay an employee more than 100% of their pay.
Okay, that's the end of the questions I have at the moment.
Okay, I've got one more law to share with you. It's just a few slides and then we'll get you back to your day. This is the public health emergency whistleblower law that I said slid in and below a lot of employers' radars last summer. So it took effect on July 11th of 2020, and it covers all employers, again, public and private, regardless of size. And it even goes beyond just employers and covers businesses that contract with 5 or more independent contractors in Colorado. So this is even bigger and broader. And this law was passed in the week-long extended session in 2020 after they broke following COVID. Same with Healthy Families, right? In direct response to COVID. So it's protecting workers who raise safety complaints. And the bottom line for this is just to make sure you're listening to your employees' complaints and you're being responsive about those. Even if you think you've done everything that public health orders at the state and local level require of you, you still want to hear from your employees if they have concerns and make sure that you're addressing them. Because this gives them an avenue to go directly to either the Colorado Department of Labor or to court with their reasonable concerns that they feel like you have not addressed. It also allows workers to bring and wear their own personal protective equipment at work if the protective equipment that they were wearing meets these 3 criteria. So the first is it's better protection than the equipment that the employer's already provided. So maybe it's a respirator versus a facial covering, something like that. It also needs to be recommended by federal, state, or local public health agencies. So that might be something that's missing because we haven't seen too much of that beyond the facial covering. Facial coverings required. But we'll see if we get more guidance on that or if we get an OSHA standard out of the new administration and the change in enforcement. And it also has to enable the person to still do their job duties. So if the person's protective equipment was so unwieldy or limited their field of vision or something that they couldn't do their job, we could say no to that. And I have had calls about that. I have had people bringing in their own PPE, sometimes homemade PPE, and that gets a little bit tough to deal with, to figure that stuff out. But these are the requirements, and we can work within those. It also protects workers, right, who oppose what they think is an unlawful practice. So if, again, I inserted what they think, right, because they may not know, or they may think they know, but it's not a reliable source, right? So if they bring the concern forward, pay attention to that concern. It also protects them if they go outside of the employer, right? They go to OSHA, if you're a private employer, if they go to some other public health authority, for example, and make a claim or assist an investigation or testify and so on and so forth, they're protected for that action, even if they're wrong. Now, if they do disclose information that they know to be false, or they're reckless about the truth or falsity of that information, then they're not protected. So somebody who, lies about a situation, or somebody who doesn't have their facts straight and could have pretty easily figured out what the facts really are, that's that reckless standard that might come to be. So like I said, they can go to the Colorado Department of Labor and make a complaint, or they can go directly to court. And I make sure that I include that one in my employment law updates, because there have been a lot of safety concerns brought forward by workers, particularly when we get to a point where we're asking them to return to work, or if they were critical workers to continue to work despite the hazard of COVID-19. I was on a panel last year. I don't know if any of you attended the Colorado Society for Human Resource Management conference. And one of the attorneys on the panel was a plaintiff's counsel. So she represents employees. And she said she was getting a lot of phone calls from people that were concerned about how their employer was responding to COVID-19. And she said, this law is something I'm going to look closely at to see if I can, help those individuals who call me about that. So I always prick up my ears when a plaintiff's counsel says something like that, because I know you don't want to be on the business end of one of those claims. So that's my content for today. We do have some additional time for questions if you have those.
I do. I have one more. Jen is asking, if someone has COVID symptoms and is out for 3 days, is that time taken out of 2020 FFCRA 80 hours or the HFWA 48 hours? She's got,
well, yeah, you only have, you do not have to provide any Families First Coronavirus Response Act leave in 2021. That is optional for employers right now. So there is no have to about it. If you choose to, and the employee still has leave remaining that they did not use up in 2020, you can do the Families First Coronavirus Response Act leave, I would say first, before any Healthy Families leave, because that's only available, right? The tax credits are only available through March 31st. So I don't know why you would wait. You would require the employee to use that first. But you can also say no entirely to the Families First Coronavirus Response Act leave and provide the Healthy Families and Workplaces Act leave. And whether it's paid sick leave or public health emergency leave depends on, again, if you have 16 or more employees. If a leave qualifies for both, if you're covered by both and a leave qualifies for both public health emergency and paid sick leave under Healthy Families, the Colorado Department of Labor has said to use the supplemental public health emergency leave first before using the paid sick leave. And I think that's because the public health emergency leave is only going to be available during the public health emergency. So that's it's a finite amount of time, even though we've been living with COVID for a long time. That is the disposable leave. So they'd like employees to they want employees to tap into that first, versus the paid sick leave, which they can use for other things besides COVID.
I have no other questions at the moment.
All right, well, thank you all very much for attending today. I appreciate your time and your attention. And I will shoot the slides, a handout of the slides to the chamber to distribute to you.
All right, now I have a list of everyone who attended, and I will start